appeal in the matter of Self and Santander Cards UK Limited, and appeal in the matter of Harrop and Skipton Building Society.
If it gets, don't take it out. Just leave it. Leave the plug in. And if it, can you not turn it off on the thing? And if it, if I need to turn it on, that's fine. That's fine. Okay. Right. Well, we have tried to improve things. Probably you've seen the sign of that thing at the back. That's the thing. Those are the things which are ultra quiet. Okay. Right. Thank you, Mr. Butters. Can I just raise one thing with you? I looked at Smith last night, both in the Supreme Court and the Court of Appeal, and I noticed that in both the cases there, the in fact payments had been made either under Appendix 3 or under an equivalent earlier provision.
Yes.
But nobody seems to have suggested that precluded the claims that were then brought in the county court. I couldn't see anything anyway. Do you know whether the point was ever taken at first, since, well, it was before a district judge and then before the county court judge?
I do. So I did appear before the district judge in Smith.
That's the question.
Compromise was run as a defence by Royal Bank of Scotland in Smith at first instance. Judge found in favour of the claimant, and that point wasn't taken further on appeal. I think
was it on the basis that there was full and final settlement?
Yes. I can't speak now to the precise wording,
no, sure.
But the essence of the defence was the same as the one pursued here by the defendant.
Yeah. Yeah.
There is a written judgment from the district judge, but I'm afraid in respect of compromise it simply says that the judge agrees with me for the reasons set out in my skeleton argument. So it doesn't give any detail that might assist the court.
No, that's often the way. Yeah. Okay.
Thank you, my lord. I finished yesterday on the Arale case, so I propose first to take the court through what I say are materially identical facts for these purposes. And we can start at AB 4, page 63. And we're in the judgment of Lord Denning. And if you look at the top of the right-hand column, you'll see, now in Dubai there was an ordinance which provided for compensation for workmen who were permanently disabled as a result of their employment. This contained a schedule giving amounts. The figure for loss of the left arm was 50% of the death compensation. In Mr. Dohal's case, at his rate of wages, the compensation for loss of the left arm was £490.69 in sterling. And then if we just skip to the next page, the top of the left-hand column, you'll see he was also paid sick pay amounting to 648 Dubai currency, QDR. And so what you can see is that actually the ordinance worked in a materially similar way to the default provisions in DISP 3, in that there appears to have been a tariff based on the earnings of the worker. So there'd be death compensation based on earnings, and then for loss of a left arm, it's 50% of that, and then sick pay would obviously be based on earnings. So there was, as with DISP 3, only one figure that could eventuate from the calculation. So in that sense, it's materially the same, I say. The next point is that, as already addressed by my learned friend, there was a provision that allowed a defendant to disapply the ordinance, Article 11C, where it could establish the worker had deliberately contravened instructions. And you see Article 11C on the right-hand column of page 100, and you'll recall the defendant's evidence was that it had no intention to invoke that provision. So as with my learned friend for Harrop, I say that is materially similar to the provisions enabling a defendant here to rebut the presumptions contained within DISP 3. And the pleadings and evidence are the same here. The defendant never put forward a case that it intended to rebut the presumptions. And then what we also see is that there is a provision, Article 4.3, that's at the bottom of the right-hand column on page 100, page 64 in the authorities bundle. The provisions of this ordinance shall be without prejudice to any right which any other law, contract of service, agreement or decision gives to the workman. My lords and lady, that's no different to DISP 3, because DISP 3 doesn't purport to exclude the rights that a complainant would have to bring a claim before the courts. This ground is not, of course, the consideration ground, so it's not necessary for me to establish, for the purpose of this ground of appeal, that DISP 3 imposed any duty on the defendant to pay the redress sum. The key point, and why I say it's materially the same as the ordinance, is that the transaction was one entirely within the statutory process, just as in Arale.
Yeah.
If I can ask the court to go back to page 63 in the authority bundle, we can see the waiver wording itself. Right-hand column. And
Where are you?
page 63,
Yep.
authorities bundle, right-hand column.
Yeah.
The first half refers to the ordinance and the calculation and ultimately the amount, and the second part is the waiver. I accept in full satisfaction and discharge of all claims in respect of personal injury, whether now or hereafter become manifest, arising directly or indirectly from an accident which occurred on 3rd July 1968. And I say immediately, the court can see that is much wider waiver wording than we're dealing with in this case. A majority, Lord Denning and Lord Justice Stevenson, with Lord Justice Geoffrey Lane dissenting, held that the waiver did not cover a subsequent common law claim. We can pick up the judgment going back to page 64 in the authorities bundle. We're in the judgment of Lord Denning, and if we go to the left-hand column at the bottom, you'll see some findings made by the judge below. The last paragraph, the judge found that in the discussion it was made clear that the receipt was not confined to matters arising out of the ordinance. He held that the receipt, just have to go up slightly, apologies. The receipt operated as a discharge of all claims, and that therefore the plaintiff's claim must be dismissed. And the majority found that the judge below was wrong to take into account that statement on the basis that it formed part of pre-contractual negotiations and was therefore excluded. If we move on then to page 65, you'll see under the heading, the construction of the receipt, second paragraph, down, that's Lord Denning dealing with the pre-contractual negotiations point. Now, I do not think that the judge was entitled to take the discussions into account. The general rule is that when a contract has been reduced into writing, evidence of previous negotiations is not admissible in order to construe it. Pren v. Simons. And then if we look to the right-hand column, we get Lord Denning's judgment on construction. You see the marked up passage. I turn therefore to the task of construction. The first half of the document is plain enough. The plaintiff is being paid the sums payable under the ordinance. The amount is the very amount prescribed. I say just so here. Then we come to the second half, which is very general, but I think it should be read as applying to the same subject matter as the first half. The word claim should be taken to refer to claims under the ordinance and not any claims at common law. It comes within the rule of construction, where a document states that a payment is made in discharge of a particular claim, which is followed by general words purporting to release and discharge all claims, then those general words are to be referred to the particular claim and to be limited to it. See the anonymous case in 1608.
Yes, referred to in Smith's leading cases, 8th edition, as edited by Mr. Thomas Denning, if he then was, 1929 or whatever. It doesn't actually say that, but I'm pretty certain you can find that's where it came from. I mean, you would say none the worse for that. But
I would, of course, my lord. And then he goes on, Lord Denning, to say that in any event, the contra proferentum principle means that the waiver should be construed against the meaning contended for by the defendant. Lord Justice Stevenson concurred, and I've taken you to his judgment already. But in that passage where Lord Denning refers to the contra proferentum principle, you'll see he says, it should therefore in case of doubt be construed against them. Furthermore, the genesis and aim of the document viewed objectively was to pay Mr. Dohal the sum to which he was entitled under the ordinance, and it should be taken as limited to that subject, see Pren and Simons. And I cite that because although Arale was decided before ICS and West Bromwich, in my submission it's clear he had the same principles in mind. And therefore I say this court should follow the approach in Arale to this case. My lords, the short point is interpreting the waiver within the customer acceptance form in light of the redress letter and what the redress letter was doing under DISP, and you have my submissions on that, then it is to be limited to the DISP complaint. Now, the word complaint that appears in the customer acceptance form is, of course, a term of art within the DISP statutory process. And what I say is that once you're in the DISP process and you're at step 2, so the firm is considering undisclosed commission, the reference to complaint means no more than complaint as appears throughout the DISP rules. It's the thing that is being the subject of investigation and assessment and potentially an offer of redress. And what's interesting is my learned friend relies on the definition of complaint for the purpose of interpreting the waiver. She sets out the glossary definition, I think it's at paragraph 57 of her skeleton argument, and I say that might be regarded as a significant concession, because if the provisions of DISP are relevant to interpreting the waiver, it rather supports the proposition that the waiver is concerned with a complaint under DISP and nothing else. My learned friend relies on it because of the wide definition of complaint, any expression of dissatisfaction. But the relevance of the width of the definition is that it renders the precise detail of the claimant's complaint letter irrelevant. Any expression of dissatisfaction, and I gave the example, if there was one sentence saying the PPI policy you sold me ripped me off, that would be sufficient to engage DISP. As I said, once DISP is engaged, complaint just means the thing that is being investigated and assessed under the statutory process. And so if the defendant wished to extend the waiver beyond DISP to a civil claim, it needed to do so with clear wording, and it hasn't done so. I also say then, looking at the opposite contention, you have my submissions on how the waiver is not capable of covering a claim under section 148C. At this juncture, I'm looking at the background facts that maybe seem to inform the party's intention. And the fact that section 148C is not a jurisdictional bar to an order under section 140B is a relevant background fact that I say the court can take into account in construing the provision as not covering a claim under section 140A to C.
Please give me that again. Which section were you referring to, saying that it's not a bar to 140A to C?
So it is agreed, I think, by all
Yeah.
parties before you that a compromise agreement does not act as a jurisdictional bar to an order under section 140B.
Oh, okay. I did hear what you said. That's
Yes.
fine.
And therefore that must be a relevant background fact that the court can take into account in construing the objective meaning of the waiver. And I say the parties are unlikely to have intended it to do something that it can't. A relevant further submission in that arena relies on an additional provision of the Consumer Credit Act that I circulated yesterday, section 173 of the Consumer Credit Act. It's not without hesitation that I introduce this because certainly in terms of the argument that was proceeded between my learned friend and I on paper and before Judge Owen, it's not a point I raised, is actually within the reply at paragraph 3C, and you can see that at core 17, page 191. My learned friend says, well, this is a new point. I'll just set out why I'm introducing it, if I may. Principally, it seems to me a potentially relevant provision that the court may wish to be aware of and take it where the court thinks appropriate. And I'm relying on section 1731. The heading is contracting out forbidden. A term contained in a regulated agreement or linked transaction. So we're in linked transaction. Is void if and to the extent that it is inconsistent with a provision for the protection of the debtor contained in this Act.
What is the linked transaction that you're referring to?
The compromise agreement, it is common ground, is a linked transaction for these purposes. So a term in the compromise agreement inconsistent with a provision for the protection of the debtor contained in this Act would be void. Now, in one sense, section 173 doesn't take the point much further for me because it is also agreed, as I've just mentioned, that the compromise agreement does not act as a jurisdictional bar to an order under section 140B. So I get to the same point by that route in any event. But the reason I bring this to the court's attention is because I say it's potentially relevant to an interpretation of the waiver, because the consequence of a provision that is inconsistent, a term, sorry, in a linked transaction that is inconsistent with a provision for the protection of the debtor is that it is void. And I would say void for all purposes. And that would render the waiver void, not just in respect to the section 148 claim, but also any other claim that the defendant might wish the waiver to cover, such as a claim under section 138D of the Financial Services and Markets Act. And in my submission, it cannot have been the party's intention to agree to a waiver that would be void. And so, in considering the competing contentions for what the term means objectively, I say section 173 supports the contention that the waiver was not intended to cover a claim under section 140A because the defendant in particular would have wished to avoid the consequence of it being void. So that's the short point on that provision. The defendant's arguments seeking to extend the waiver to a civil claim rely on picking out elements of the document to seek to demonstrate that it has a wider ambit. And in chronological sequence, those documents are the complaint letter of the claimant in 2018, then the redress letter in 2021, and then the customer acceptance form. And the defendant relies on the fact that the complaint letter sought full repayment of all PPI premiums, and as you've seen, there is reference to section 140A in the complaint letter, but I say that's to be interpreted as a reference to section 140A as it appears in the wording in DISP. What the letter does not mention at all is a civil claim, and that's unsurprising because it's written by a claims management company. And you have the point already, the precise content of the letter doesn't matter, it's the fact that it contains an expression of dissatisfaction about the sale of PPI that triggers the DISP process. So I say the fact that the claimant sought return of all PPI premiums is properly to be regarded as falling into pre-contractual negotiations. In Arale, the statement that the waiver would extend beyond the ordinance was disregarded, and so should the statement of the claimant 3 years nearly prior to the redress letter should also be considered no more than a statement of aspiration by the claimant. In any event, it made no difference to the defendant's response under DISP. It's never been suggested that the redress letter, other than the particular financial terms that it refers to, is bespoke to the way in which the claimant had expressed the complaint in 2018. It's obviously a standard redress letter written by the defendant. And the fact that the claimant sought full repayment does not, in any event, indicate any contemplation of a civil claim. First, the default remedy for an upheld PPI mis-selling complaint, step 1, is a full refund. And secondly, as you've seen, the default remedies under DISP are not exhaustive, so it is theoretically possible for a firm to decide it's going to apply DISP Act 3 in terms of the presumption and find that redress is due, and then be more generous than the default provisions. And therefore, one cannot read into the fact the claimant was seeking more in 2018 an interpretation of the CAF that extends it beyond what the defendant was clearly doing, which is simply offering the default redress sum under the rules.
It doesn't arise in your case, but what are the implications for what you say is the default position if, for example, as happened with Mr. Harrop, during the period of the policy you made you made a claim which was successful, the policy paid out. How does that feed into assessment of the appropriate redress?
Well, my lord, I suspect that may be a ground upon which a firm may, in certain circumstances, wish not to apply.
Or would say it's not appropriate to have full refund.
Perhaps. I can't give a direct answer as to what a firm would do.
As a matter of principle, it must be capable of being relevant to remedy.
Well, one would think it is potentially relevant. What I'd say in relation to our appeal, it's just not the facts of our case.
No, I know.
And it goes back to ground one. The defendant was following the default provisions, and that's what's relevant in this case. A case where the defendant, for whatever reason, decided not to follow the default provisions, whether justified or otherwise, may give rise to different arguments, but it's not the case here, and my understanding is it's not the case in Harrop either. And so I say, when it's so clear what the defendant is actually doing here, the reference back to the claimant seeking full repayment 3 years ago is of little consequence. It doesn't shift the fundamental object or genesis of what the defendant is doing. And much the same, my lords and my lady, applies to the redress letter itself. Now, I accept that the waiver wording that is contained within the redress letter is somewhat wider than the waiver wording one sees in the customer acceptance form, although I say it's no wider than the waiver wording one sees in Arale. The redress letters at supplemental bundle page 32, that's tab 7.
Yeah.
And you'll recall it's just above the heading details of our offer that we get the first waiver wording.
Page.
Page 32.
Thank you.
In your case, the amount we've received is over 50%. Therefore, we'd like to offer you £830.84 in full and final settlement of your complaint and any claim that you may have against SC UKL and New Day in respect of RND Commission. And then, if we go to the bottom of page 33, last sentence, if you accept this offer, it will be in full and final settlement of this and any other claims relating to PPI you may have against SC, UKL, and or New Day. But of course, when we get to the customer acceptance form, as you've seen, and I'll go to that in a moment, that just refers to settlement of undisclosed commission complaint. So the actual contract entered into is narrower than those words. Now, I fully accept that reading the wording, one would naturally think, well, claim must be something different to complaint.
So is the analysis this, that the last contractual offer, if that's the right way of putting it, is that contained in the acceptance form, which is then accepted by Santander paying the sum?
That's my case,
That's your case.
my lord, yes.
So in that respect, you can say that the redress letter is either a prior negotiation or but not a contractual document.
I'd say it's not a contractual document. I think I'd have to concede its relevant background. I rely on it myself to say the defendant's clearly operating under DISP, and there's a dispute between the parties on what the defendant was doing in that letter. But looked at against the full context of what the defendant was doing, the fact that the defendant has added in the wording "and any claim" should not, in my submission, subvert what would otherwise be the interpretation of the wording in the customer acceptance form. And I first rely on Arale for that proposition, because you've seen how wide the waiver was in that claim. But this court found that it was limited to the ordinance. I rely on all the background facts, and I also rely on the fact that the customer acceptance form refers only to complaint. So if any claim is something other than a complaint, it didn't translate through to the customer acceptance form. And if the defendant is making a distinction between complaint and any claim, then it must follow that it's only the complaint that's settled by the customer acceptance form.
So there's no difference between, on the customer acceptance form, between complaint, which is defined with a capital C, and the lowercase complaint in the last line.
I say not, but my last heading under this ground appeal will be ambiguity, and I'd say that would be a pretty stark ambiguity if the defendant was relying on the use of a lowercase rather than capital C. We can move on then to the customer acceptance form, page 41. And you've seen this before. I'm accepting the payments in full and final settlement of my non-disclosure of commission complaint, the complaint, and there is some further wording then. I agree that by accepting the payment, this fully settles the complaint against SC UKL and or New Day, and that SC UKL and or New Day have no further liability to me. Now, I say that doesn't take matters any further. It still doesn't refer to a civil claim. It's still referring back to the complaint. So it's doing no more than set out what the consequences are of settling the complaint. And then the wording goes on to say, if I raise further issues on the same or similar terms, I understand that SC UKL and or New Day may choose to rely on this acceptance form as proof that such issues have already been settled. Well, in my submission, that again doesn't take matters further. It's still referring back to the complaint, but that isn't words of waiver. It's an indication of a point the defendant may take. And in my submission, it's actually consistent with the way in which Section 140A operates. Because of course the defendant may choose to rely on the fact that the claimant has signed up, if you like, to this wording as a countervailing factor in the assessment of fairness. There'd be nothing to stop the defendant making that argument. And the defendant would be able to do that whatever status at common law is accorded to the waiver. So I say actually that wording rather it supports the claimant's case. It's entirely consistent with the notion that a compromise cannot be a jurisdictional bar to a claim under Section 140A. So my next heading, before I move on to ground 3, is ambiguity. And this can be looked at either through the contra proferentum principle, which still survives in cases of genuine ambiguity. See Lord Hamlin and Burnett and Grant International, paragraph 29. Insofar as it's subsumed into a general principle that clear words are required to deprive a person of an important legal right, then the same argument applies. And for that principle, I've cited Lord Leggett in Triple Point Technology and PTT Public at paragraph 111. And that's AB 23, page 591. Contra proferentum, as I've already submitted, was an alternative basis for the decision in Arale. And a construction of the words non-disclosure of commission complaint that extended to civil claims, and in particular a claim under Section 148C, would obviously deprive the claimant of rights under the general law, and in this context, deprive a consumer of an important right designed to provide protection. It is clear, I don't think I need to enumerate the reasons why, if I fail on my primary submission that the waiver is clearly limited to a claim under DISP, or at least does not extend to a 140A claim, it is ambiguous. And there are several obvious ambiguities that flow from the submissions I've already made, and therefore the interpretation should be that the interpretation contended for by the defendant should be rejected. So I'll move on then to ground 3. it's not in dispute that the compromise does not act as a jurisdictional bar. It's not in dispute that the compromise cannot prevent the claimant alleging that the non-disclosure of commission gives rise to an unfair relationship, and cannot prevent the court taking that into account in the assessment of fairness. It's conceded that the settlement agreement is a linked transaction and therefore a related agreement to the credit agreement, and therefore forms part of the overall assessment of fairness. And the question, therefore, is simply whether the compromise agreement has acted so as to remove the unfairness in the relationship that existed prior to the compromise agreement as a consequence of the non-disclosure of commission. Judge Owen found at paragraph 38A of his judgment, that's core 8, page 108, that the relationship was unfair up to the point of the compromise, and in my submission, that's obviously a correct finding given Plevin. And I make the point in my skeleton argument that the logical approach for the court would be to consider the question of fairness up to the point of the compromise, and then consider what, if any, countervailing weight the compromise has. That's not at odds with the approach in Smith. The court still has only one assessment to make of the whole relationship, but logically, if the relationship wasn't unfair up to the point of the compromise, there'd be no need to look at the compromise. It clearly was.
You would say it's an application of the kitchen approach, that you take the elements which, let's assume, you find are unfair, and then the compromise agreement, you look to see what impact that has.
That's absolutely
right.
That's absolutely right.
But does it make a difference whether one does it stepwise or whether one looks at it in the round? Shouldn't it? Shouldn't make a difference, should it?
Not at all. I say that the test is clear. The court has to consider the whole relationship and consider all the factors in the round. The point I was simply making is that logically, if it's not unfair before you even get to the compromise agreement, that's the end of the matter, but that's not where we are in this case. The Supreme Court in Smith made clear that even where the court finds an unfair relationship, it may decline to grant a remedy. That's clear from the discretion inherent in the statutory wording, and gave an example of a debtor sitting on his or her hands and bringing a claim, albeit within limitation, that would otherwise be regarded as stale. Mr. Justice Nugie, as then was in the Hollyoake case, was content to proceed either by way of looking at the effect the compromise agreement had on the fairness of the relationship, or on whether he should make an order under section 140B. I say it doesn't matter in this case. One follows from the other on the facts of our case. If the relationship is unfair, notwithstanding the compromise agreement, then it would be just to make an order to remove that unfairness. The decision in Hollyoake was handed down some time before the decision of the Supreme Court in Smith. So insofar as it could be regarded as setting, if you like, a threshold test of bona fide compromise before the court can even consider the assessment of fairness, that cannot now be regarded as good law. It's all part of the one assessment of the relationship. And it follows from that the binder factors that Mr. Justice Nugie referred to as being relevant to the resolution of the issue as to whether there's a bona fide compromise may, of course, be relevant considerations in the assessment of fairness. But there is only one question the court is asking itself, which is whether the relationship is fair or unfair. The decision of Judge Owen as regards what binding compromise had in fact arisen at common law is at paragraph 18 of his judgment. That's core 8, page 101. He held, it's in the middle of the paragraph, on an objective reading, both the offer of redress letter and the customer acceptance form, which have in any event, for the above reasons to be read together, compromised any further claim to the return of the PPI premiums on whatever basis. So it does appear the judge was holding that the compromise agreement precluded at common law any claim under section 140A referring to undisclosed
Any claim at all.
PPI
Just
commission,
any claim.
which would be any claim at all on
Any
the...
claim arising out of these facts.
Indeed. So he wasn't finding that the compromise agreement at common law did no more than preclude the claimant from alleging undisclosed commission in support of an unfair relationship. He found that it precluded the claim. And that is the binding compromise that Judge Owen then considered in respect of the question of fairness. And so we can go slightly back to ground 2, because what I say is that that cannot have been the effect of the compromise agreement. And in fact, the high point of the compromise agreement would be that it precluded a claim under section 138D of the Financial Services and Markets Act, for example. But it's conceded by my learned friend, and the judge proceeded on this basis, that whatever the compromise agreement is, it could not preclude the undisclosed commission allegation being considered in the assessment of fairness. And so the judge then went on to undertake that fairness assessment. The Deputy District Judge had almost got the approach correct in Judge Owen's eyes, but he was a little concerned about some of the aspects of the way the Deputy District Judge had expressed himself, and so Judge Owen conducted the overall assessment of fairness himself, and he found, in summary, that the compromise agreement cured the unfairness. See paragraph 38 of his judgment. And I say Judge Owen was clearly wrong to do so. And my final submissions will be setting out the reasons why. First, I accept the fact that merely because the claimant gives up what might otherwise be a strong claim is not necessarily by itself a factor that would render the compromise agreement of no effect in the assessment of fairness.
Sorry, are you accepting that it doesn't necessarily preclude a finding of unfairness, or are you accepting that it's not necessarily relevant to that question?
What I'm saying is, generally speaking, it's not enough for a claimant to say, well, I've entered into a compromise, but that's a bit unfair because I had a really strong
Well, I understood you to say a moment ago that as a general proposition, that the fact there's a compromise agreement doesn't without more, enable the claimant to say, well, I had a very strong claim, therefore, even though there's a compromise agreement, the relationship's still unfair.
That is Exactly my point. There are additional factors here beyond the mere fact the claimant had a very strong claim, but obviously that is a factor.
Yeah.
And it's not only that the claimant had a strong claim, the defendant didn't have an arguable case on unfair relationship. It's difficult to come up with any sensible argument the defendant could make against a finding of unfair relationship in these circumstances, and an unfair relationship was held to have existed by Judge Owen. So the claimant's position isn't to downgrade or diminish the importance of good faith settlements and the finality that brings. We don't dispute the propositions relied on by the defendant, but as the defendant would have it, the points of policy are all on their side. But if we're looking here at some form of binding compromise, then there are countervailing policy considerations revolving, of course, around consumer protection.
I don't know if you can help on this. One of the things that has puzzled me, it may simply be ignorance of the detail of this area of the law, but obviously the FCA has chosen this formula, which the sort of 50% formula, which it seems to me will in most cases leave a consumer claimant somewhat short of total recovery.
Yes.
I mean, was there some discussion about that at this stage?
As I understand it, I think it's in evidence in the Harrop appeal.
That was what was referred to? I can't remember what it was now, Mr. Mann. But
yeah, there are various areas of discussion papers where the countervailing considerations are put into play, and the FCA explains why it's taken one route. Very much a sort of policy driven rather than, as I was trying to say yesterday, rather than individual circumstance driven. I can take the court to that at a convenient moment. It might be useful to look at that. I rather thought that actually yesterday, that it might have been helpful to have that.
yeah, okay. Well, let's just see how we go. Okay, yes.
I mean, my submission on that, except it's not in evidence in our appeal, but it's somewhat of a compromise between, obviously consumer bodies would have liked more to be paid back.
Yes.
One can assume banks would have liked less, and so the FCA came to its conclusion and its rules. But of course,
it's not an answer, because I suppose you would say, because unless the statutory regime actually says in terms, well, if you pay out this, then that cures any unfairness in the relationship under section 140A to C, which it doesn't.
yes,
Then you say these arguments about unfairness of the relationship remain open for debate.
that's absolutely right.
So, and the battleground is between whatever it is, 16% was Mr. Mullins, an acceptance that some commission is not of itself rendered the relationship unfair, and the very high levels of commission which were being, and it's a nice round number, but they've taken 50 as being what Mr. Mullin describes as a systemic solution.
Yes.
But it's not, and doesn't purport to be, a full solution in an individual case.
That's absolutely right, my lord, yes.
So if leave aside the compromise, someone could go to the institution and thence to the financial ombudsman and say, well, in my case, nothing less than full return of premiums will do, based on whatever it is.
They absolutely could.
I would never have entered into this at all. I've received no benefit. I want the whole lot back.
Absolutely, and it's unsurprising that's what most claimants say in proceedings.
Yeah. Well, Mr. Harrop is perhaps unusual in that he only says he may
Yes,
refuse to take it.
yes. Well,
But that's not your problem.
Well, he'd actually had some benefit because of the payment out under the policy.
he has.
Made by claimants like your client is, well, I haven't really got anything out of this at all.
That's absolutely right. And my learned friends for Harrop have set out in their skeleton the differing approaches that county court judges have made. But as I pointed out in this case, if the approach to remedy is only to pay the claimant back the commission on the basis that she should at least pay for the premium element, that is a very small deduction from the full value of her claim in the circumstances here.
And what the solution, DISP 3 solution, effectively assumes is that commission up to 50% does not render a relationship unfair,
That's right.
which, given the terms of section 140 A to C, cannot be, I was going to say, a full and final assumption.
Cannot be a complete answer.
Cannot be a complete answer.
No, absolutely. And insofar as it might be said, well, the court should take into account the approach of the regulator. First, it's of no significance when the court is undertaking an individual assessment of the facts pertaining to the relationship in this case. But secondly, the Supreme Court made clear in Plevin the relationship can be unfair notwithstanding what the position of the regulator is. So if we look at the facts in this case, we have the unfair relationship on the one hand arising from the non-disclosed commission, and you have the defendant using the statutory redress process itself designed for the protection of consumers, by which the claimant ought to have received payment unconditionally, to extract a waiver from the claimant of a larger claim, and thereby using that statutory redress process to further its own interests to the disadvantage of the claimant.
I think you want that sentence to appear in the judgment somewhere. I mean, that's at a non-legal level, or not particularly legal level. That's your complaint.
It absolutely is, my lord, and it is done so without the claimant having legal advice. And it's done so in circumstances where the wording isn't at all clear, where a complainant may think they're doing no more than signing for administrative purposes to receive the payment, or indeed, on this premise, the defendant has got over the contra proferentum principle, but only just. And it cannot be said that the claimant has received any additional benefit in receiving the redress sum, because what was the alternative? For the defendant to decide not to comply with its regulatory duties. Well, first, that's not the defendant's case. But secondly, that cannot be a benefit that the court takes account of in the assessment of fairness in the context of a provision for the protection of consumers. And so the only possible answer is that the compromise did not.
I didn't get your sentence completely, Mr. Butters, but the gist of it is the defendants are using the quotes minimum payment to preclude further investigation of the merits of unfairness claim by grafting on terms of full and final settlement. That's the gist of it.
That's absolutely right. And using the process designed for consumer protection.
I'm not saying it's going to appear in any judgment or that I might be involved in, but at least that's the gist.
Yes, I follow. And so, simply in conclusion, when the court asks the question, is the relationship unfair, taking into account the allegation of undisclosed commission and any countervailing weight attributable to the compromise agreement, whatever the scope of that is, the answer, and the only possible answer, is that the relationship is unfair. Unless I can assist you further, those are my submissions.
Thank you very much, Mr. Butters.
My lords, my lady, I am going to deal with matters in response in the same order essentially that my learned friends have done, starting first with the consideration point in round one of the appeal, and then turning to section 140A. So to start with consideration, before getting into the detail of this part of the appeal, it is in my submission worth stepping back to focus on exactly what the appellant is seeking to achieve by this ground. we have here a settlement agreement by which Skipton paid the appellant a little over £1,000 in full and final settlement of claims arising under the mortgage protection, payment protection insurance contract that the appellant took out. Now that payment would ordinarily, straightforwardly be regarded as good consideration for the settlement of the claims, because payment of money is, of course, in normal circumstances, obviously good consideration. It's important to emphasise that it is the payment of the settlement sum which provides consideration for the settlement. And although that may be obvious, on a number of occasions during the course of submissions yesterday, I think both of my learned friends referred to there being a prior obligation on Skipton to make the offer of settlement, and that because of that, the offer was not good the offer, they said, was not good consideration. But the offer isn't the consideration on any view. The consideration is the payment of money. And as I will go on to establish, there was no obligation on Skipton to pay the settlement sum prior to the conclusion of the settlement agreement. So what the appellant is seeking to do, what the appellants have to do, is to contend that that payment of money was not valid consideration in the way that it normally would be. And there were various references yesterday in the course of argument to it being in discharge of a prior legal obligation. But of course, since the consideration was payment of money, the only possible relevant prior legal obligation that could be discharged by that payment of money is a prior legal obligation to pay money. In other words, a debt, in essence.
Oh, it has to be a debt.
Well, not all obligations to pay money are debt, but if one is going to say that the basis on which a payment of money is not good consideration because it's discharging a prior obligation, is because it essentially falls within the rule in Folks and Beer. And that bringing the settlement payment within the scope of that rule is, in my submission, really the only way in which the appellants can succeed on this point. If they can do that, they can say that the payment was simply discharging a prior obligation, a prior debt, and was not good consideration. But otherwise, they can't succeed. And the difficulty that the appellants face is that the rule in Folks and Beer is a narrow one. It doesn't apply generally to legal obligations in some undefined way. It applies to undisputed debts. Payment of some or all of an undisputed debt cannot constitute consideration to support a counter-promise. But the rule doesn't apply to disputed debts, and it doesn't apply to claims for unliquidated sums. And the judge in Harrop sets out passages from Chitty at paragraph 53 of his judgment, which is on page 86 of the core bundle. He rightly describes those as uncontroversial. I've set out various authorities at paragraph 7 to 9 of my skeleton argument, page 52 of the core bundle. And again, I understand from my own friends, none of that is controversial on this appeal.
Give us the paragraph number again.
Paragraph 53 on page 86. And he sets out various passages there which are your reference in the authorities bundle at page 780 and following.
Sorry, I've got something wrong here. Could you just give the references again? CB core bundle 52.
Core, my skeleton argument is core page 52, paragraphs 7 to 9 of the relevant paragraphs of my skeleton argument.
Thank you.
The judgment, paragraph 53 is the relevant paragraph, that's at page 86. And the extract from Chitty begins at page 780 of the authorities bundle. So rather than challenging the limits to the rule on folks and beer, which I said haven't been controversial on this appeal, what the appellant is trying to do is to bring himself within the rule by relying on the DISP section of the FCA handbook, which is said to give rise to a sufficient payment obligation for this purpose. He also then relies, as a sort of second string to his bow, on the terms of the redress letter that was sent by Skipton, which he says constitutes an admission, and which again he says is sufficient to bring the case within the scope of the rule in folks and beer. And I'm going to break down my answer to that line of argument into 4 points. First point is to say that the DISP section of the FCA handbook does not create any liability in respect of a liquidated sum payable by way of redress. So the rule of folks and beer simply cannot apply. The second point is to say that it's no answer to suggest, as the appellant does, that there can be an obligation to pay a sum notwithstanding that it's not possible to claim for that sum. It's no answer because A, a debt falling within folks and beer is one that could be claimed for, and B, an agreement which permits a claim to be made for a sum in circumstances where you couldn't previously claim for it is necessarily supported by consideration. My third point is to say that reliance on admission doesn't help. There's 2 reasons I say that. Firstly, there was no admission, as the judge found. And secondly, because there simply is no liquidated sum that is capable of being admitted as due. And fourthly, to answer a point that perhaps is addressed in writing, perhaps slightly more than it was addressed orally yesterday, but to address the argument that somehow the sum that is due was crystallised. And in my submission, that concept simply doesn't apply in this context. So the first point then is to focus on DISP and whether or not, in fact, it creates any liability to pay a liquidated sum by way of redress. And perhaps I could start with the rule that is relevant, which is Rule 1.4.1, which you were taken to yesterday at page 864 of the authorities bundle. It's referred to in the skeleton arguments, it was alluded to yesterday, that there are 3 kinds of provision in the FCA handbook. One is the rules marked R, and breach of a rule is subject to a claim under section 138D for damages if you're a private person. There's then evidential provisions which can be used to demonstrate breach of a particular rule, and then there's guidance. And this is the only rule that we need to look at. And it begins on the very first line, once a complaint has been received by a respondent, it must. And that use of the word must, I emphasise, because it's usual for the rules to say you must do or you must not do a particular thing. The evidential provisions are worded differently, and we come on to see they don't use the word must. And you've seen the structure of it already. The complaint must be investigated and assessed. That's steps 1 and 2 of the rule. And that assessment involves determining what redress or remedial action may be appropriate. And subject to the requirement that the assessment be fair, consistent and prompt, there's no rule or anything else in most cases that spells out what form that redress must take or how substantively it should be determined. The PPI rules are relatively unusual in that respect. We then see that there must be an offer of redress or remedial action if that's appropriate. That offer is accompanied with an explanation, which is step 4. And then step 5, the requirement is to comply with any offer of remedial action or redress which is accepted. Now, 5 points in my submission flow from that structure. The first is that the starting point is that the firm needs to make an offer of redress where it's appropriate to do so. That offer can be accepted or rejected. But if it's rejected, there's no question of the regulated party being under any obligation at all as regards the rejected offer. Possible that the complaint will be pursued further by other means, but the rejected offer itself is just that, it's rejected. There can be no obligation to comply with it at that stage, and there's certainly no payment obligation at that stage. There's no payment obligation at all until the offer is accepted. That's the point at which the offer of redress must be fulfilled. So, on any view, you have offer and an acceptance. Even taking these rules at their highest, there's no prior obligation under these rules to make payment prior to the point about which the offer is accepted. The obligation is concurrent with what we say is the formation of the contract. The obligation under the rules, under sub 5 of 1.4.1, we say the offer and acceptance process gives rise to a contract, so I'm going to come on to that. But the obligation under the rules is concurrent with the formation of the contract. It's not prior to it. And of course, Folkes and Beer is only concerned about prior obligations. The second point is to address the argument raised yesterday that this process is somehow non-contractual. This process of offer and acceptance. Non-contractual, merely procedural, I think is one of the descriptions given to it yesterday. And it's simply part of a discrete scheme of regulatory redress. Now that argument doesn't explain why the scheme of regulatory redress cannot permit contractual settlements as part of that process. And indeed, there's nothing at all in the rules which prevents or causes the usual rules on contractual formation to be disapplied. And indeed, the use in the rules of the terminology of offer and acceptance almost inevitably, my submission, takes us straight into the sphere of contracts. The use of that language cannot be coincidental. And where there is payment of money, combined with there being consequences to the acceptance of an offer of redress, it's entirely natural to anticipate consideration for a contract. And indeed, in other circumstances, in the context of other complaints, where there's no equivalent to Appendix 3, which sets out in detailed terms what the redress should be, there's then no basis for an equivalent argument in those other cases, that there's no consideration in the way the argument founded on Appendix 3 is put here. In those,
Can you just do that again?
but in the cases here, the basis for the argument that there's no consideration is premised on Appendix 3. And the argument was, well, Appendix 3 tells you what you've got to pay, and that's what creates the obligation. Therefore, when you simply pay that amount, you're discharging the prior obligation as no consideration. In cases where there is no equivalent to Appendix 3, in other words, where most complaints, where you don't look to the rules in Appendix 3 or any other equivalent rule to determine what the redress should be, the firm simply assesses it for itself based on the circumstances. In that context, there would be no argument equivalent to the argument brought here that there could be no consideration. And on that footing, if you're saying that there's got to be consideration, you have offer and acceptance, well, it's plainly, in my submission, going to be a contract in precisely the normal way that one would expect. The third point I want to make is to emphasise the need for acceptance of any offer of redress. That is a critical part, in my submission, of the scheme of these rules. What they provide for is a mechanism for the consensual resolution of complaints. They do not require the redress to be paid regardless of whether or not it's accepted. They could well have done so. You could easily draft a rule that has that effect. But that's not what these rules say. It's an essential part of the way they work, that the acceptance that the redress has been offered resolves the complaint and brings it to an end. And against that context, my submission is that an offer of redress and full and final settlement is consistent, entirely consistent with the operation of these rules. And there's certainly nothing that prevents an offer being made on that basis. The fourth point is to address the appellant's position that an offer of redress can be accepted, that stops a reference being made to the Ombudsman, but it doesn't bar a later civil claim, because they say you have two separate schemes, one that lies entirely within DISP, of which the Ombudsman forms a part, and another outside it, where one comes to the court. So they say you can accept your redress and then come back for more from the court. Now my submission is that if that were permitted, we wouldn't have consensual resolution of the complaint. That would be a system of part payments. And indeed, if that were truly the position, there would never really be any reason at all to refuse an offer of redress, unless for some reason you really wanted to go to the Ombudsman. Because you could always just accept it and then pursue your complaint further before the court. And that, in my submission, cannot be how these rules were intended to work. It's also at odds with the effect of going to the Ombudsman. Because if you go to the Ombudsman makes an award in your favour, then that award prevents subsequent legal proceedings being brought on the same basis. And authority...
And where do we get that from?
Well,
So once you get a determination by the Ombudsman,
yes,
by the FOS service, that's a full stop.
it creates an estoppel res judicata.
Okay.
And
Which rule is that?
the authority for that proposition was cited before the Deputy District Judge. I don't think it was actually mentioned in the hearing before her. And it's in my skeleton argument for that hearing, which is in the core bundle at page 211. We don't, and one sees there, it's the decision of the Court of Appeal in Clark and In Focus Asset Management and Tax Solutions Limited.
211, hang on a moment.
At the very top of the page.
Clark.
Oh yeah,
And in
Clark and
focus.
in focus.
Yes. Now, unfortunately, that hasn't made it into the authorities bundle for this hearing, simply because I hadn't anticipated that it would remain relevant. But in the light of the way the argument was put yesterday, it is in my submission a significant factor that if you go to the falls, accept an award, you are then barred from coming to court on the same point. And if that's the position, why should consensual resolution at an earlier stage, before you go to the falls, be in principle any different?
Please can you explain to me if you accept a payment which is made, which is offered to you under 1.4.1, you are then barred from going to the Ombudsman? You only go to the Ombudsman if in fact you've rejected that offer
Quite.
and your complaint remains unresolved.
Yes.
So you can't take a part payment and then go to the Ombudsman.
Where's that in the rules, in the DISP?
Well, the best place, I think, to find it is the passage that you were taken to yesterday by Mr. Butters in the second supplemental bundle at page 110, which is the introduction to DISP. I have to confess, it's not spelt out perhaps quite in the obvious terms that might want it to be. But one sees there a passage in the middle of the page about under the headings chapter 1 and chapters 2 to 4, which you were taken to yesterday. And it's under the heading chapters 2 to 4, makes the point about that chapters 2, 3 and 4 deal with how the FOS considers unresolved complaints. it's also, if I can find the reference, yes, if one looks in the main authorities bundle at page 868, at the bottom of that page, rule 1.6.2, that sets out what the respondent to a complaint must do within the 8 weeks of the period of the complaint being made. And they must send a final response, one sees at sub 1, and that must contain various pieces of information. And at E, the penultimate subparagraph, we see they must inform the complainant that if he remains dissatisfied with the respondent's response, he may now refer his complaint to the Financial Ombudsman Service. Now, I accept that that doesn't say in terms, and you can't refer it otherwise, but it is implicit in that, and it's one sees from the way that the introduction to the rules sets out the scheme that one refers matters to faults where you are not satisfied with the redress that's already been offered. So that was the fourth of my points, flowing from 1.4.1.
Yeah.
The fifth point is that nothing in these rules provides any basis for a liability arising from the rules in debt. A breach of Rule 1.4.1 is actionable by way of a claim for damages under section 138D. And of course, that's not a claim for a liquidated sum. There was an attempt, I think, yesterday to argue that it was or could be the equivalent by seeking to follow through from the provisions of Appendix 3 back to 1.41 and say, well, that sets out very clearly what the sum should be. If you don't pay that, then you're in breach and damages will flow. But even if in a particular case, damages that would be payable under section 138D can readily be calculated, and of course that may not be the position at all in particular facts of the case, that doesn't make a claim for damages a claim for a liquidated sum. The only way in which a claim in debt can arise, in my submission, is if there has been the acceptance of a contractual offer of redress, which then gives rise to an obligation to make payment of the sum offered by way of redress. And indeed, that provides a far more straightforward way of enforcing compliance than the consequences of my learned friend's argument. If one has an offer of redress that's accepted in full and final settlement, and then the redress is not paid for whatever reason, in breach of the rule, and we would say in breach of contract. On the appellant's case, the disappointed complainant has to claim damages under section 138D, but can't just claim the sum that was offered as a debt. We say that more straightforward case is open to a complainant in those circumstances. If you've concluded a contract and the firm's not complied with it, well, you can sue in debt. It's a very straightforward claim, and there's likely to be no answer to it. It's a straightforward solution to the problem. So that benefits complainants just as much as it benefits firms in having the benefit of an agreement in full and final settlement. So those are the points I want to make on 1.4.1. If I can then turn to Appendix 3, which starts at page 943, but if I could ask you please to turn to page 960. 960, which is the first passage I'd like to focus on, if I may. Apologies, it's 961. And the passage I want to highlight is the provision at the very top of the page, 3.10.3E, which makes clear the contravention of an evidential provision in this appendix, and all the provisions we're looking at really are evidential provisions, may be relied upon as tending to establish contravention of DISP 1.4.1. So what that's showing is that breach of the evidential rules in this appendix can be relied on as establishing a breach of 1.4.1. So this whole scheme, therefore, is directed towards telling firms how the obligation in 141 to assess the redress that is offered should be conducted. But it's not concerned with payment obligations at all, because the payment obligation comes only at a later stage if the offer of redress is accepted. Then just working backwards, further up the rules at page 960, I think you were taken to 3.9.4 yesterday. This is the provision that says the firm should explain the offer of redress, including the consequences of accepting the offer of redress. And in my submission, it is inherent in that provision that it's accepted, that if an offer of redress is accepted, well, that will have consequences. It can have consequences. And the most obvious and likely, indeed most natural consequence of accepting an offer of redress is that it should be in full and final settlement of any claim which gives rise to the complaint. Nothing in the rules prohibits an offer of redress being made on that basis, and it's consistent with the rules in my submission that it should be. If what these rules are saying are redress in accordance with these rules is an appropriate offer of redress to make, then it is entirely reasonable in my submission where that offer of redress is accepted to treat that redress as being the end of the matter. Because
could it consequences are if you accept the sum that you can't go to the ombudsman?
well, it could mean that if that's the basis on which the offer is made, but there's nothing which prevents the offer from being made on a wider footing.
So I thought that if you do accept what's offered by the firm and after the Act 3 procedure, then you have settled your complaint.
Yes, you can't then go to the ombudsman.
I use the word
Yes.
in the wider sense.
You can't then go to the ombudsman.
And it's only unsettled complaints that go to the ombudsman. So a consequence of accepting the sum is you can't go to the ombudsman.
One consequence is that, yes.
A consequence.
I accept that.
And so the reference to consequences of accepting could be that.
Well, except that it is put in broader terms. It is, you've seen part of the rules that any offer must say, well, if you don't like this, you can go to the ombudsman.
Yeah.
It's implicit that if you do, you're happy with this,
You can't.
you wouldn't, you can't, and you wouldn't. But this is in more general terms. This is not simply saying well, you have to explain the consequences of that you cannot go to the ombudsman. It's saying you have to explain consequences generally. And so there can be consequences. And it's consistent with this to say, well, one of those consequences is that this is in full and final settlement of any claims. And so you, not just you can't go to the ombudsman, you can't go to the court. And that has to be explained. But there's nothing to say that that can't be one of the consequences of accepting the offer. And for the reasons I've already given, it's consistent with the process in 1.41 that it should be. So then, if I can move back to page 957, where we get to the key provisions on redress. Redress at step 2. As I think it was explained yesterday, at step 1 is essentially concerned with mis-selling. Yeah. And if it's concluded that there was mis-selling and redress is given under that heading, that redress in most cases, the starting point would be repayment of all the premium. In those circumstances, you don't get on to step 2 at all. You only get on to step 2 either if there's no mis-selling at all at step 1, or if there has been mis-selling at step 1, but in the circumstances of the particular case, the consequences of that mis-selling is not that the product wouldn't have been sold at all. In other words, there might have been some mis-selling, but the product may still have been brought. In those circumstances, you go on to look at step 2. And the first point to address is 3.7a.2. Which is headed duty to remedy unfairness. And it was suggested by my learned friend that this provision imposes an obligation to remedy the unfairness. But it, in my submission, cannot be quite that. Because at most, what these provisions do is require the firm to make an offer. Undoubtedly, the offer should be one which, if accepted, will remedy the unfairness. But that's different from saying that there is an obligation, as it were, come what may, to remedy the unfairness. So that's 3.7a.2.
I'm not sure I follow that. Should remedy the unfairness. It's not saying should make an offer to remedy the unfairness. It's saying should remedy the unfairness.
But, my lord, one has to put this all in the context of being provisions which direct the firm as to how it should go about complying with its obligations under 1.4.1. That's the context of this. And the scheme of 1.4.1 is very clear. You assess your redress. These provisions tell you how to do that in this context. Having done that, you then make an offer of whatever redress is found to be appropriate.
By you.
Yes, in
But
applying these
doesn't
rules.
detract from the obligation to remedy.
Well,
It just simply provides a pathway if your offer is perceived to be inadequate.
well, if the offer is rejected for whatever reason, then it's
What pathway
Well,
is
that's
there?
I mean, that's really the nub of the plan. I mean, if the offer is rejected, that's one thing. But we're in the scenario where the offer isn't rejected, and the issue is whether these provisions are exclusionary. In other words, if you're right in saying, well, all you've got to do is make an offer, and if they accept the offer, that's an end of it. I can see that point, but that's not what this says. And the concept of the unfairness is an objective concept, isn't it, under the statute?
well, that's getting on perhaps more to the section 148 point.
Well, but they're all part and parcel of the same
Well, to an extent,
issue, really. aren't
to an
they?
extent. But on the 148 point, we say, well, if the offer is not accepted, then plainly the unfairness hasn't been remedied. And this perhaps is my point on the duties aspect of 3.78.2. If the offer was made and it was a proper offer and it was rejected, you couldn't then say, well, there was some breach of this duty, because the firm's done everything that's required of it in making an offer. And if the offer is refused, then you're not required to do anything more. So that's why I put caveats around the suggestion that
But
this
you can
provision
only
contains.
ultimately tell whether you've remedied the unfairness if you get down to a hearing which carries out the entire exercise of balancing all relevant features.
Well, that comes on to the question of, if the offer is accepted, is the unfairness remedied?
Well, you might make an offer which you genuinely think is going to remedy the unfairness, but later on, the court decides that that's wrong, and you've just mistaken, and the offer wasn't good enough. You wouldn't have remedied the unfairness by making that offer. On these words.
Well, that comes back to then the question of the impact of the settlement on the approach to the assessment of unfairness. And I'm going to get onto
No,
this
I
in
understand that's
section.
a different point.
But to explain in a nutshell, the problem with the way the appellants put their case on this point is that yes, they accepted that the settlement has to be taken into account, as they have to in the light of Smith. But when doing that, effectively, they almost did it as a balance sheet exercise. It's taken into account because this particular sum has been paid. In my submission, it's more than that. It's not simply the amount of settlement, paid by way of settlement, that has to be taken into account. The very fact of settlement is an absolutely critical factor relevant to assessing unfairness. The fact is that the parties have agreed that the sum offered is a sufficient remedy to compensate for the unfairness. And that fact of agreement, which the appellants tend to overlook and de-emphasise in the way they put their case, but that in my submission is critical. So I'm going to come on to develop that point when I get on to section 148, but in a nutshell, that in my submission is a key aspect of this.
But your point in relation to should remedy the unfairness in 3.7A2 is that you're saying that must be the offer because you can't force the money on somebody if they don't want to take it. What are you to do?
Milady, that's exactly right. That's what I say. So then, if I can go on to 3.7A, 3A, which starts at the bottom of the page.
Yeah.
You've been taken through this. And the words that my learned friend emphasised is the obligation that the firm, at the end of the first line, the firm should pay. And those words should pay are said by the appellants to create a freestanding and binding obligation on the firm to pay the redress calculated in accordance with this rule. That, in my submission, is not right. It's not right, firstly, for the reason I've already given, that the whole purpose of these provisions is to demonstrate compliance with Rule 141, which focuses on the making of an offer, and there being no obligation to pay anything at all if the offer is rejected. Secondly, if one turns on to page 959, and again, I think we were taken to these provisions yesterday, 3.83 and 3.84 make clear that 3.7a is not exhaustive and it should be departed from where appropriate. And it doesn't matter that these provisions were not relied on in this particular case. What they do, in my submission, is demonstrate that the word should pay in 7A, 3A cannot impose a payment obligation. Because there's not a payment, there's not a specific obligation to pay that sum. This is one way of calculating it, but if circumstances dictate, you should do something different. That's broadly the effect of those rules when read together. So that's not saying there is a specific obligation to pay the sum in the first provisions. It's saying, well, that is your starting point, that may be what you do, but you can think about doing something else if that's appropriate. That's not a payment obligation, in my submission. It's inconsistent with the notion that 3.7a creates a payment obligation. And indeed,
But 3.8. I don't see how the 3.8.4 helps you on that argument, because this surely is focusing on what the firm should do at the stage when the complaint has been made, and it's assessing the complaint. In other words, what it's doing is looking to see whether the formula 3.7a 3a is sufficient to remedy unfairness, and it may conclude that the answer is no, it needs to pay more.
or indeed it needs to pay less.
So what it then offers is tailored accordingly. But when it comes to what the obligation is in terms of payment. And then 3.7A3A is simply looking at the position where that's the remedy for unfairness, isn't it?
Well, that's the starting point for the assessment of redress that's appropriate in these circumstances. But that's all it is. My learned friend says that the word should pay imported specific obligation to pay a specific sum of money. My submission is that they don't do that. They set up a starting point for assessing the redress, and that starting point can then be departed from if the firm thinks it's appropriate to do so. We see that in 3.8.3 and 3.8.4. We also see that on the next page on 3.9.2. Firms should consider if there's anything else, essentially, any further reasonably foreseeable losses. And if so, take those into account as well. So all of that in my submission demonstrates that the word should pay in 3.7a do not equate to an obligation to pay or must pay as it would if it were a rule. If it were a rule, and that's what my learned friends seek to elevate it into, and when I say rule, I mean a rule marked R rather than a rule marked E, because technically the ones marked E are rules as well. But if you elevate it into a rule marked R, it would have said you must pay, not you should pay, because that's what all the rules marked R do so. So in my submission, these rules cannot be read as giving rise to an obligation on Skipton to pay a liquidated sum to Mr. Harrop. That's simply not their effect. They just provide a mechanism for determining how an appropriate offer of redress should be determined. And that's the conclusion that was reached by Her Honour Judge Belcher in Taylor and G. Money, and that decision was then followed at first instance in this case by Deputy District Judge Wilcox and upheld by Judge Khan. And in my submission, both of those decisions were correct on that basis. So that's the first of my 4 points. The second point, and that point in my submission answers the premise of this ground of appeal, that Skipton's offer of settlement wasn't valid consideration because it was merely discharging an offer to discharge an existing payment obligation.
I'm slightly losing the structure. Where you said that concludes your first point. Where did your first point start? Was it when you took us to DISP 3?
The DISP 3 did not create a liability in respect of a liquid.
Well, no, the first overarching point was the point about DISP generally. The fact that DISP generally does not create a liability.
So your first overarching point was DISP doesn't create any liability and effectively
Yes.
Then you went to DISP 3.
That's still part of my first overarching point, looking at the effect of DISP
So
generally.
are we starting on second arch now?
Now we're starting on the second overarching point.
Thank you.
Yeah.
Sorry if that's got slightly lost, my lord.
So where are we now?
But that first point in my submission answers really the premise of the appeal, that there was simply an offer to discharge an existing payment obligation. There's no debt created by the rules and no room to say that the settlement offer was merely an offer to pay a prior debt. And indeed, paragraph 22 of his skeleton argument, my own friend, that's page 36 of the core bundle, my own friend acknowledges that he could not have sued for the sum that the DISP rules provide should be offered by way of redress. And that repeats a concession made on the first appeal, which is recorded at paragraph 47 of the judgment at page 85.
No, he says it's a section 138D point.
Well, he acknowledges he can't sue for it as a debt. You can claim damages, but damages aren't within the scope of the rule in Folks and Beer, unliquidated claims. So the fact that one can claim damages under section 138D, if rule 1.41 is not complied with, isn't the same thing as saying that the offer made in accordance with 1.4.1 is simply discharging a prior obligation. It's a damages claim, not a debt claim, and B, the timing doesn't work in my submission. It doesn't establish, you can't establish a prior obligation that could form the basis for a claim under section 138D. The appellant's answer to this is to say, well, one can go under section 138D, but also to say that it doesn't matter that there's no legally enforceable debt, provided there is a legal obligation to pay the sum in accordance with the DISP framework. It doesn't matter that you can't sue for that sum. It says just so long as the DISP framework provides for it. Now that argument's not right in my submission. First, for the reasons I've already given, because DISP doesn't create any payment obligation at all. Second, because it's difficult to follow the distinction on which the point is founded. The point is founded on the argument that there can be a payment obligation which engages the rule in Folks and Beer, but nonetheless not a payment obligation that's legally enforceable. And that, in my submission, that distinction has no basis for it. One can have supervening events that render a debt unenforceable, but it's difficult to understand how a party can be under a legal obligation to pay a fixed sum of money without there also being a debt claim that's enforceable. And in support of this point, my own friend relies on a case in Arale and Costain. And perhaps I could just go back to that, although I appreciate you've seen several different aspects of it. And you've seen my own friends taking you through the facts, and the fact that on a 2-to-1 majority, the Court of Appeal in that case decided that the settlement in that case covered only the statutory Dubai claim, not the common law claim. So the common law claim, for that reason, could be pursued. For that reason, my submission is what was said about consideration after that. It was purely obiter. Mr. Mallin took you through some of what was said. And perhaps I could just go back firstly to what Lord Denning said at page 66 of the bundle. Under heading 2, in the left-hand column, the consideration for the agreement, Lord Denning begins by setting out the problem. And about halfway through that first paragraph, he says, what is the consideration? It is just like the acceptance of a smaller sum in discharge of a larger. What is the consideration for the creditor giving up the balance? So here, sum paid is the exact sum payable in order to discharge the claim under the ordinance. What is the consideration to discharge the claim at common law? So where there he's referring to the question of us paying a smaller sum to discharge a larger, that's a direct allusion to the rule in Folks and Beer. And my own friend says when he gets a bit lost after that, but it's useful to look at how exactly he gets lost. Because if one looks at the next paragraph, where he says, thus the question, was there consideration or not, would seem to depend on whether the two claims are to be regarded as severed into two or combined into one. That would be a poor way of deciding whether an agreement is binding. I would not accept it. He then says, the doctrine of the common law about a smaller sum being no consideration for the discharge of a larger is no longer valid. It has been replaced by equitable principles. In a case like this, instead of asking, was there good consideration, we should now ask, was there a true accord and satisfaction? And he goes on to address that point and to decide that there was no true accord at all, and described it as an instance of inequality and bargaining power. But what's striking about that is in one sentence, he, as it were, sweeps away the rule in Folks and Beer simply by saying, well, that's no longer valid, disregarding the fact that he's thereby effectively overruling a decision of the House of Lords and just simply dismissing it.
Well, it didn't normally stop him.
Well, no, quite, my lord. This is perhaps not untypical. But in my submission,
He refers to D&C Builders and Rees, doesn't he?
well, he does. But my point is that one can't really extract much from that by way of a ratio on which one can found oneself. If one goes on then page 69 to see what the other members of the court said. Page 69, where we have Lord Justice Stevenson, and I think you were taken to this yesterday, but in the left-hand column, in the penultimate paragraph of his judgment, he says, I agree with my brethren that on the evidence there was no considerations for the reasons which they give. So he was agreeing with both Lord Denning and Lord Justice Geoffrey Lane, without really giving any reasons of his own, and without in fact acknowledging, as we will see, those two judges themselves gave very different reasons for their decision. So again, one can't, in my submission, extract a huge amount from that.
It's all good.
Quite.
He makes both of them 2-1 up. Their reasoning. I mean, I would accept this is not the most powerful or deeply reasoned argument that the world has ever seen, but that is the effect of what he does, isn't it?
Well, logically, I can see the force of what your lordship is saying, but it's very difficult to follow when the rationale given by those two judges are very different. And when one's starting point also is Lord Denning's approach of effectively ignoring a well-established common law principle, difficult to see how one can then follow that subsequently. What we can do is look at Lord Justice Geoffrey Lane at page 70. And he then, at the bottom of the left-hand column under the heading consideration, says, was there any consideration for the plaintiff's promise not to sue at common law? The defendants, by paying the workman's compensation money to the plaintiff, were doing no more than perform an obligation already cast upon by law, and that would not be good consideration for a promise by the plaintiff not to sue. And he refers there to Stilk and Myrick. Although he doesn't mention Folks and Beer, that in my submission is an entirely conventional application of that principle. And in fact, Stilk and Myrick is in essentially the same principle, but applied not to payment of money, but to the provision of services under a contract. And there, of course, one gets into more complicated questions as to whether or not practical additional benefits count as good consideration. One doesn't have that difficulty with Folks and Beer in terms of payment of money. So the principles are different in that respect, but essentially it's the same point. But what one can't do...
Was Stilk and Myrick the basis for the decision in Williams and Roffey?
Yes.
Because it's not pure. Williams and Roffey is not pure Folks and Beer.
No. Stilk and Myrick, you remember, was the sailors' case.
Stilk and Myrick is the case about sailors who demanded more money for doing what they already agreed to do.
Quite, for the contractual services that they had already contracted to that same party to provide. And there it said, well, you're just doing what you've already contracted to do, not good consideration. And Williams and Roffey says, well, there can be circumstances in which there's a practical benefit, and that constitutes good consideration. Because Folks and Beer, one can say payment of money always gives a practical benefit. And having money is always better than not having money and having debt.
We don't need to go down the Williams and Roffey line. Or anything like that.
No, because under Folks and Beer, it just doesn't arise. One doesn't have that line of argument at all. But what the learned friend does is refer to that phrase, performing an obligation already cast upon them by law, and seeks to elevate it into a much broader general principle. And in my submission, it can't be relied upon in that way. All this is reiterating the principle of Folks and Beer, because what we had in this case is a statutory debt under the Dubai Ordinance, which there was an obvious legal obligation to discharge. And if what was done was discharge that debt, well then that plainly falls squarely within the principle of Folks and Beer. My learned friends say, well, this shows that if there's an agreement to pay a sum of money that there's already a legal obligation to pay, then it's not good consideration even if that legal obligation is unenforceable. That's what he relies upon it to establish. But it's not clear in my submission how the case can be authority for that proposition at all, because there's no suggestion at all here that the sums due under the Dubai Ordinance were not legally enforceable. One would entirely expect that they would be. Indeed, it would be an odd statutory provision for compensation of injured workers if the injured worker couldn't sue to recover the sum payable under that statutory compensation. And certainly none of the judges articulated that principle, the principle that my own friend relies upon, or based their decision on that reasoning at all. So all we have in this case is essentially a conventional application of Folkes and Beer in my submission to an undisputed debt created by statute. Nothing more than that. But my next answer to my learned friend's line of reasoning is to say, well, if there is an unenforceable obligation here, contrary to what my learned friend argues, an agreement that renders enforceable an obligation that was previously unenforceable is supported by consideration, notwithstanding the prior unenforceable agreement, because there is benefit in making enforceable that which could not previously be enforced, and that constitutes good consideration. I've made the point that it's difficult to understand that sort of concept in a bipartite situation. If one imagines a tripartite situation for a moment, it's easier to follow. If A promises B to pay C, then at common law, C cannot ordinarily enforce A's promise. An agreement between A and C to pay the sum that A has already agreed with B to pay to C will be supported by good consideration, despite the fact that A has already promised to pay that sum, promised to B to make payment of that sum.
You use that example in your skeleton.
I do, my lord.
Is that Harrop, Parmesan and Temple?
It's New Zealand shipping and Santander,
Yeah.
which I was about to go to.
Yeah, okay.
It's at page 32 of the authorities bundle. And one sees that this was arose from a dispute that arose from the bill of lading for shipping goods to, I think, New Zealand. And the bill of lading incorporated the Hague rules, which included a discharge from liability unless suit was brought within a year. And the bill of lading stipulated that that immunity was extended to the carrier's servants or agents, including independent contractors. And it says, just reading from the head note, the carrier was a wholly owned subsidiary of the company of the stevedore, who acted as the carrier's agent in New Zealand. And the carrier had authority to enter into the contract on behalf of the stevedore. So the carrier entered into the contract with the company that was shipping the goods. The stevedore then, through their negligence, damaged the goods, which was a drill. And the consignee brought an action against the stevedore more than 1 year after events had happened. And the stevedore pleaded the time limit in the bill of lading. And the Supreme Court in New Zealand, so I think the first instance court in New Zealand upheld that defence. The Court of Appeal allowed an appeal by the consignee on the ground that the shipper and the stevedore were not bound by the contract at the time the bill of lading was signed, and because at that stage no consideration moved from the stevedore. And this came to the Privy Council, and Lord Wilberforce gave the speech of the majority. And the relevant passage starts at page 44. And one sees at the top of the page, the question is identified. The question in the appeal is whether the stevedore can take the benefit of the time limitation provision. There's reference then to the House of Lords in Midland Silicon and Scruttons. And he says there's no need to question or even qualify that case insofar as it affirms the general proposition that a contract between two parties cannot be sued on by a third person, even though the contract is expressed to be for his benefit. And a bit further down between C and D, he says Midland Silicon left open the case where one of the parties contracts as agent for the third person. And he says Lord Reed's speech spelt out 4 propositions, the prerequisites for the validity of such an agency contract. And then those propositions are set out in the quote. And the only one we need to worry about is the 4th one, just above letter F, that any difficulties about consideration moving from the Steve law were overcome. And if one turns over then to the top of the page, Lord Wilberforce goes through the first 3 of the requirements in Midland Silicons, and at the end of the first paragraph from the top of page 45 says all this is quite straightforward and was accepted by all the judges in New Zealand. The only question was and is the 4th question presented by Lord Reed, namely that of consideration. And then he goes on in the paragraph just after that to say, well, this is obviously not intended as a gratuitous promise. We should be realistic about it being a commercial contract, and it'd be surprising if it were without consideration, but there are technical difficulties in finding where that consideration is. And he then finds the bottom of page 45 onto the top of page 46. He says there's more than one way of analysing this business transaction into the necessary components. That which their lordships would accept is to say that the bill of lading brought into existence a bargain, initially unilateral but capable of becoming neutral, between the shipper and the appellant, made through the carrier's agent. This became a full contract when the appellant performed services by discharging the goods. The performance of these services for the benefit of the shipper was the consideration for the agreement by the shipper, that the appellant should have the benefit of the exemptions and limitations contained in the bill of lading. So it's the performance that founds the consideration in this case. But then at just above letter E, the sidebar passage, he says the following points require mention. In the Lordship's opinion, consideration may quite well be provided by the appellant, as suggested, even though or if it was already under an obligation to discharge to the carrier. No direct evidence of the existence or nature of this obligation, but the Lordship is prepared to assume it. An agreement to do an act which the promisor is under an existing obligation to a third party to do may quite well amount to valid consideration and does so in the present case. The promisee obtains the benefit of a direct obligation which he can enforce, and then authority is cited to that. But here too, although it's not a 3-party case, it's a 2-party case, if my learned friend is right that the DISP rules give rise to essentially an unenforceable legal obligation, there is still good consideration to be found in converting that unenforceable legal obligation to an enforceable one, which can be enforced by suing on the contract. And indeed, this case demonstrates that there is no general principle that performing an obligation ever imposed by law can't constitute good consideration. The principle is that there's no consideration if you're agreeing to pay to someone some or all of an existing undisputed debt which is owed to that person. But in other circumstances, the mere fact of a prior legal obligation isn't an absolute bar to consideration being found. So that's my second overarching point.
Forgive me for being so slow. I can see on satisfied establishes the principle for which you've just contended, where you've got a tripartite situation. So you're bringing someone else in.
Yes.
How does that work in the context of a bipartite situation where you've got the claimant and the defendant?
Yes.
How's that work?
The answer, my lord, is in the benefit that's identified in Satterthwaite. The promisee obtains the benefit of a direct obligation which he can enforce in circumstances where there previously wasn't one. Now, my starting point in a bipartite situation is that one doesn't normally get legal obligations which can't be enforced.
So in your bipartite case, you're saying the claimant may have had an unenforceable obligation, or you may have had an unenforceable obligation to pay, assuming you had an unenforceable
An obligation that the complainant couldn't enforce,
pay,
yes.
which they couldn't enforce. The fact that under the settlement agreement they could then enforce, because they could enforce the settlement agreement, it means it's good consideration.
Well, yes, and it's precisely the same benefit that's identified as providing the consideration in Satterthwaite.
Okay, sorry, that's been very slow.
No, not at all, Rob. But my starting point, of course, is that in bipartite situations, one doesn't normally get unenforceable legal obligations.
Well,
But the principle in the remuneration is only really applicable by analogy, isn't it? Because this is dealing with a classic
In one sense,
tripartite problem.
in the sense that this case is tripartite, the Satterthwaite is tripartite.
Derived from the earlier English case.
Yes, and this is bipartite. Yes, I accept. That's not a direct analogy.
I'm not suggesting that it doesn't apply by analogy. I'm simply making the point that it's not directly on point.
I agree, of course, that this is not a tripartite case, and Satterthwaite was. But the key point I emphasise is the benefit that's identified as forming the consideration. And that, in my submission, is a benefit that would exist in this case, notwithstanding that it's bipartite, not tripartite.
Yeah. Okay.
That takes me then on to my third overarching point, which is to deal with my learned friend's reliance on an admission, and what he says ought to have been found by the judge below to have been an admission. And he focuses on the redress letter that was sent by Skipton and relies on the use of the word due in that letter to support the argument that Skipton admitted a legal liability to pay the sum that was being offered by way of settlement. The judge rejected that argument and concluded that the redress letter was not an admission. It may just be worth quickly turning up the relevant pages in the judgment. They're at page 89 of the core bundle. It's 69.1 at the bottom of the page. And he referred to the letter. He refers to Mr. Clark's construction of the word due as not being an admission of a sum, which is Skipton. I think I should say the construction of the word due is that it is an admission of the sum which Skipton is obliged to pay. But he then says, but as Mr. Wheeler explained, it's nothing more than an acknowledgement of the requirements of DISP 3. And then on the next page, at 69.2, he makes the point that the offer of redress made to an offer in full and final settlement of all of the claims, says that this was an offer chimes in with what was said in Mr. Harrop's name in both the particulars of claim and the witness statement of Miss Rogers. That was the witness statement in response to the application for summary judgment. And then he says at 3, the redress letter did not specifically admit any unfair relationship between Skipton and Mr. Harrop, but acknowledged that the non-disclosure of the commission was above or had the potential of being above 50% of the premiums at the point of sale. The redress letter did no more than confirm that in the circumstances, Skipton was required to presume that this created an unfair relationship. And it may just be worth, given the reference in 69.1 to what I had said previously, looking back up to page 87, the bottom of that page, paragraph 58, where that's put into context slightly by the judge's setting out the point that I made and that he was accepting. So one can see slightly fuller there the argument that he was accepting. And in my submission, the judge was entirely right to reach that conclusion for those reasons. And if I can deal with that by going to the supplemental bundle and ask you to turn to page 230.
Sorry, Mr. Wheeler, page.
230, my lord. I think think it's divided
Mr
14.
Gibson, in his witness statement, it does express, which was put in for the purposes of the application,
Yes.
does at the bottom of one page, I think penultimate page, say Skipton denies any suggestion that this was an unfair relationship.
Yes.
That's the only time that it's, well, that I've seen that is asserted.
Yes, I think that's probably right. I think it's fair to say that the
It's not the
substance of the underlying claim really hasn't been addressed. I'm going to come on in the context of my submissions on section 148 to look a bit at what that would involve. It's not quite as straightforward as been portrayed, but I'm going to come back to that if I may.
Right.
So on page 230 we have the formal pre-action letter of claim. And I do just emphasise that this letter is sent as a letter of claim under the civil procedure rules, therefore in a sense necessarily envisaged the prospect of litigation. And we've seen on the next page there are various allegations of mis-selling, including in the fourth bullet point an allegation of failure to explain the true cost of the policy. Then on the third page we have a reference to section 140A and the demand for information about commission and whether it was disclosed, which is clearly in my submission intended to raise a plevin type claim, and certainly foreshadows one being brought if it emerges that there is substantial undisclosed commission. And the redress sought is return of all of the premium plus interest. So it's a wide-ranging claim on several grounds, seeking much more than was ultimately offered and accepted. If I could ask you then to turn on to the redress letter, page 246. The first point, just to flag the second paragraph, this is not payment protection insurance, it's mortgage payment protection insurance. I'll come back to the significance of that a bit later if I may. The various allegations were then rejected and we don't need
What's
to...
the significance of that?
Well, the significance of...
Lost me by completely.
Well, the significance is that section 148 does not normally apply to regulated mortgage contracts. Where the regulated mortgage contract is the credit agreement, they are outside the provisions of section 148. And this was protection insurance where the credit agreement was a mortgage.
So what?
Well, so that if, and there's quite a, I'm going to come on to this point later, but there's quite a complicated argument because of the date of the mortgage. It's a 1990 mortgage, so it predates Financial Services and Markets Act and the regulations made under it. But there is an argument that the mortgage is exempt for the purposes of section 140A, so therefore section 140A simply doesn't apply to this mortgage at all.
Okay, well, speaking entirely for myself, that's passed me by so far.
Well, it's not been emphasised, my lord, and it's not.
Excuse me, sorry to interrupt. It's not only not been emphasised, it's been no part of the case, to my
Well,
understanding.
I find it rather surprising because I thought we were all proceeding on the basis section 148 did apply.
We have been, my lord, and we say that it does,
Well,
but it certainly hasn't been raised against us as far as I'm aware.
My lord, it's one has to understand the
pleaded at this point.
one has to understand the context in which I'm raising it, my lord.
Is it pleaded?
It's not pleaded, no.
No,
because
well,
we
it's
haven't
not a
pleaded
point that's
anything.
open to you then, is it?
It's not a point that's open to me today. I'm not seeking to make the point today. That's not why I raise it.
Well, let's just deal with points that have been raised, Mr. Wheeler, and not rather than ones that
Perhaps I'll
haven't.
come back to explain.
What is its relevance in the context of the argument that you are advancing?
Its relevance on the section 140A side of things is that when one's looking at is this a fair and reasonable settlement, one has to look at what the claim would be and the hurdles that the claim would have to overcome to succeed on that claim. And that's one of them. That's its relevance. That's not a point that was raised on the original summary judgment application, or that I seek to argue on its substance at all, for the reasons that my learned friends identified. I'm not seeking to do that in any way. But I simply flag it as a point that if this case hadn't settled, as it did, and if a claim had then been brought, that is one of the points that would have had to have been addressed. That's the reason I make the point. So if this case went on to trial, if a defence were to be pleaded, that would be a point that was pleaded.
So we're on page 246.
Yeah, lady, yes. And in fact, I think we can go on to 247 and pick it up at the bottom, where the letter turns to consider the section 140A claim. And at the very bottom, we have the final paragraph. The letter says, I've considered whether any redress is due in relation to commission plus profit share we received during the period the MPPI policy was live. And that phrase, whether any redress is due, is explained by the paragraph at the top of the next page, where it said that the FCA has established that redress is due in instances where there was non-disclosure of commission that resulted in an unfair relationship. The commission at the point of sale was or had the potential to be more than 50%, etc. We are required to presume this created an unfair relationship. So there's no concession in this letter that there was an unfair relationship.
Well, hang on. There's a rebuttable presumption that it's unfair, and you take no steps to rebut it.
No, all that's said is the next paragraph. We see exactly what's said. Having assessed the MPPI products held, we found there was a non-disclosure of commission and that this was above or had the potential to be above 50% of the premium
On this
at the
basis.
point of sale. So,
On this basis, it's 1,095.
yes,
So it's proceeding on the basis that it's unfair and no attempt to rebut the presumption.
well, it's proceeding on the basis of an acknowledgement that there's a presumption that has to be applied in those circumstances. There's no attempt to rebut that presumption.
So it's proceeding on that assumption.
So on the basis of that presumption, there's then said to be that on that basis, a refund is now due. But all that's doing in my submission is acknowledging the requirements of DISP.
But the requirements of DISP that render it unfair are rebuttable. If you wanted to say that this is what DISP says, but this was not an unfair relationship, then this was the time to say it.
And you could then have said, notwithstanding that our position is that
We'll offer you, and then
we'll offer you
then you'd have a very
£1,075.
nice consideration argument.
That's not what you did.
No, that's not what was done. Of course, it's right to say that all sorts of different things could have been said. But all this is doing, in my submission, is acknowledging the requirements of DISP. And the mere fact that the word due is used cannot, in my submission, be understood as an admission at all. All it's saying is, well, if one follows through the rules, based on what they say, based on the fact of commission being above or having the potential to be above 50%, then following that through, this says we have to pay, or we have to offer to pay, redress. That, in my submission, cannot be understood as an admission. And of course,
It's a non-contested presumption.
yeah, I'd accept that, I think, yes.
Well, what's the difference? Where's the hair's breadth difference between that and an admission?
Because it's one thing to say we're required to make this presumption, and we're not going to go behind it. Saying that, in fact, this was unfair is very different in my submission. Because that's a positive acknowledgement of the state of affairs.
I mean, this wording actually goes further than what the provision actually says is that there's a rebuttable presumption. There's a presumption which can be rebutted. So you could have said, well, there's a presumption which can be rebutted. We're not going to seek to rebut it. But you actually go slightly further than that, don't you? In this wording here, you actually say we're required to presume this created an unfair relationship. And that seems to me to go
And
about
we
as
do-
close to
well,
saying we admit it's an unfair relationship as is possible.
It doesn't get into the detail of all the rules. I mean, that's absolutely right to say. But
I mean, it's fair to say it's sort of, we've had our arm twisted behind our back, so we have to admit it, but it's still an admission.
it's an acknowledgement that DISP requires, or DISP provides for payment to be offered. That is what it is in my submission. It's no more than that. And indeed, what is offered, and one sees this after the breakdown of the sum is set out, 2 paragraphs below that, if your client is willing to accept this offer, I'd be grateful if you complete and sign the enclosed acceptance form. What is being, that sum is being offered in full and final settlement of everything that was claimed by the appellant. And of course, he had sought repayment of all of his premiums with interest. And the offer was made to settle the entirety of that.
Excuse me.
Yeah.
Not just the claim under section 140A, but the other claims that were asserted, mis-selling claims that were asserted. An offer was made to settle the entire of that very much disputed claim by payment of that sum that was offered. And one sees that the offer is made, acceptance is required. One looks to the letter of response at 254.
Well, what's striking again is that the mis-selling aspect, your client isn't saying, well, we think your mis-selling case is a pretty hopeless one, but as it were in the mix, we'll give you £500. It's saying your mis-selling claim is hopeless and we completely reject it. And then they go on to deal separately with this issue of the undisclosed commission.
Well, the letter certainly,
The basis on which it's asserted against you.
the letter's certainly structured in that way. But what one has is an overall response to a letter which sets out a series of claims. And the totality of that response is to say, well, we'll offer this sum in full and final settlement of everything you're claiming.
Hold on, where does it say that? In this letter?
Conclusion, I cannot uphold your client's complaint about mis-selling. It says misspelling, but it presumably is mis-selling. And I appreciate my decision will be disappointing. And I trust I've been able to explain.
Where does this letter say full and final satisfaction?
Well, that one finds in the acceptance.
No,
And
where
in
does
the-
this letter say in full and final satisfaction?
I don't think this letter uses the words.
Well, I'm just asking you because if it does, I've missed it.
I don't think this
So
does.
what you've got is the thing, I'm sorry to be tendentious about this, but you've got a letter which is you accept is structured so that, to say, as my lord says, this selling claim is hopeless, then changes tack and deals with the section 140 claim, says we're required to assume, doesn't, and then says 105.9575 without saying anything about being full and final satisfaction.
Subject to the response form that was enclosed with the letter, which is at page 255,
Yes.
and that makes very plain that the sum is being accepted in full and final settlement of my stroke our complaint.
And I think Mr. Gibson says expressly in his witness statement what is obvious from these papers, which is that it was calculated specifically and precisely on the basis of the DISP 3 approach.
Yes, that was the basis that was used to determine that sum.
So forgive me for just wanting to be clear about this on the facts. As far as I can see, the first suggestion of full and final satisfaction comes in FRS's covering letter. We confirm we're instructed by our client to accept in full and final settlement, and in the acceptance form.
Well, except that, of course, the acceptance form was sent with the redress letter, was sent in blank with the redress letter, and is then returned. So in terms of timing, that form comes at the same time as the letter.
Yes.
We then have it in its form as signed and returned.
It
Slightly
went
later.
out with Skipton's letter and it came back with FRS's letter.
quite, came back completed. So we have it in the bundle at 255 with the letter under cover of which it was returned, but it was of course sent in blank with the redress letter. So it's not right to say that as a matter of the chronology, the first reference to full and final settlement is in the response letter.
I think it's the difference between this case and self, which again, I may be wrong about, so please help me if I am. This letter doesn't say, if you want to accept this sum, please return the enclosed acceptance form, whereas in self, Santander, I think, do say that.
No, this letter says that as well.
Does it? Where I missed it?
If you're on page 248,
Yeah.
if you see the little table that breaks down the sums,
Yeah.
2 paragraphs below that, if your client is willing to accept
Thanks
this
so
offer,
much.
we'd be grateful if you complete and sign the enclosed acceptance form.
Thank you, I missed it. Okay.
So, and that was obviously enclosed with the letter, as you've seen. Well, you've seen it in its, as I say, its returned form. And indeed, as my lord has observed, the letter under cover of which that was returned acknowledges quite openly, quite straightforwardly, that sum was being accepted in full and final settlements of the claim. And it's the claim for missold payment protection insurance. So that clearly sees as the settlement as being bringing within it everything that's raised in the original letter, the mis-selling allegations, and plainly the Section 148 claim as well.
And how does this work on a purely contractual analysis? How do you characterise the offer? Do you characterise the offer as the sum which is set out in the redress letter plus the reference to the acceptance form, and therefore the offer is from you is £1,095 in full and final settlement, or is the contractual analysis that you offer it on terms that the acceptance letter's got to be, or acceptance form's got to be returned. So then the terms of the agreement, final agreement, are laid out by the acceptance form and accepted by payment. Does it make any difference?
Well, I'm not sure it does make any difference in my submission. And of
Well,
course,
it'd be nice to get it right.
we don't have the sort of argument on contractual interpretation that we have in self. So this hasn't had the same sort of focus as it does in that case. But in my submission, one has an offer that is contained in the redress letter, accompanied by the form of settlement on those terms, and that is then accepted by returning the form signed.
And if that were not to be right, then Plan B works, which is the acceptance form sets up the basis upon which the money will be accepted, and then you pay.
Yes, yes.
Thank you.
So the judge referred to both of those documents in his interpretation of the letter. He referred to the particulars of claim, and I can just, I think, give you the reference rather than taking you to it. It's paragraph 8 of the particulars of claim at page 8 of the supplemental bundle, where reference is made to an offer to pay rather than an admission of liability.
Sorry, which paragraph?
Paragraph 8, my lord. By letter dated 1st of February, the defendant stated he received unfair commission and as a result offered to pay the claimant that sum. And then at page 27 of the supplemental bundle, the witness statement of Ms. Rogers, paragraph 3A, making the point where it said that, well, it said the offer made by the defendant was unsupported by consideration. And again, it's accepted there that it was an offer, characterised as an offer, not an admission. And more broadly in my submission, we have a letter that was sent on behalf of the appellant advancing a variety of claims, seeking the return of all of the premiums paid on the policy. And in response, we have an offer of settlement on the basis of repayment of part of what is claimed. There was in my submission quite plainly a dispute between the parties. And therefore a dispute capable of settlement. And on the face of it, my submission is that this is an offer of settlement to resolve that entire dispute. And the court ought to be very slow in my submission to read a letter that was plainly intended as containing a bona fide offer of settlement as making an unconditional admission. Effectively what the appellant is saying is that instead of either instead or as making an offer of settlement in this case, Skipton effectively made an admission which made it impossible to reach a binding settlement agreement on the terms that were being proposed. And that, in my submission, would be an extraordinary outcome. For the appellant to be able to accept payment from Skipton on the basis of it being full and final settlement, but then to be able to escape the consequences of the settlement on the basis that the offer of settlement itself amounted to an admission of liability that prevented the settlement from being binding. That's effectively what they're arguing. And in my submission, that simply can't be right. On that basis, my submission is the judge was correct in upholding Deputy District Judge Wilcox in treating this letter as an offer of settlement, not an admission of liability. I'm going to come on to deal with whether, if I'm wrong on that point, it helps the appellant, but it maybe that's
Yeah, is that a convenient
a
moment?
convenient moment.
Right, 2 o'clock, please.
Court rise if able.